met. I'm Jackie Lipton. I'm the co-director of the Law Technology and the Arts Centre and the associate director of the Cox International Law Centre here at the Law School. One of my real pleasures in this role is organising the Case Abroad at Home program, which is a program where every year this week, the week before the semester starts, we invite 3 international visiting professors to come and teach mini courses, intensive courses to our upper level students. And today's speaker is one of those professors. We always have one visitor from Canada, largely in honour of our Canada-US Law Institute, and Dan Uzzo is here from that institute. And we also have another of our Case Abroad at Home presenters up the back, Professor Linda Gao from Fudan University in China, and it's delightful to have her here. But it's my pleasure today to introduce the public lecture by our other visiting professor, Meera Sundararajan. She holds a Canada Research Chair in Intellectual Property Law at the University of British Columbia in Vancouver, which is an absolutely beautiful setting, but they've just demolished the law building to build a new one, so she's kind of homeless at the moment. I think she's very happy to have an office here. She might not leave at the end of the week, I don't know. She has a DPhil from Oxford in intellectual property issues. She is the author of the 2006 book Copyright and Creative Freedom, a study of post-socialist law and reform. She's also developing and editing a book on Eastern European intellectual property law, and the topic of her talk today is based around a third book that she's been working on that's coming out next year, I believe, 2010, and that book is entitled Moral Rights and New Technology, and that will be published by Oxford University Press next year. So without further ado, I'll hand it over to Professor Sundararajan.
Thank you very much, Jackie, and very grateful to Jackie for the invitation to come back to CASE. This is my second visit here, and tremendously enjoyed my first visit, and the second one is shaping up to be even more pleasant. I have things here that I don't have at home anymore, such as an office and access to photocopying and prosaic things like that, but they do make a difference, so there you go. So the presentation today is about moral rights, entitled Moral Rights, the Future of Copyright Law. And as Jackie did mention, it's the subject of a book on which I'm currently working. And I'm particularly excited about this seminar because it's really the first occasion that I've had to talk about this work in public. So I hope you find it as stimulating as I do. So, moral rights, a mysterious and controversial area of copyright law. And I have so much to tell you about this area that we could spend the rest of the evening here. But rather than do that, I'll try to confine my remarks within the time available to the items that I've indicated in the outline here. So I'll start with a brief and practical definition of moral rights, move on to talk about the moral rights landscape in the United States with reference to 2 benchmarks, the Shostakovich case of 1948 and the Daystar case of 2003. I'll then go on to describe the international approach to moral rights in the Berne Convention for the Protection of Literary and Artistic Works, which is the main international convention for the protection of copyright law. And I will then go on to talk about the global approach to moral rights. In particular, I'm going to take an example case from each of the jurisdictions that I've identified here, the UK, Canada, India, and Russia, to show you how this doctrine has made its way around the world and how courts in different cultural and legal contexts interpret this interesting area of the law. Chances are we will run short of time, and if that happens, I will probably leave out the section on Russia, but feel free to ask about it in the time that's allotted for questions. And finally, conclude with a few words on why I think moral rights will have an important future right at the heart of copyright law and reform in the digital era. The theory behind moral rights is actually very simple. Is everyone able to see the lettering mostly. Can we do anything to turn off a light or something up by the slides, maybe? Some of us have better eyesight than others, perhaps. Okay, well, I'll be telling you about it anyway. So the graphic is really actually the most important part of this chart. So as I was saying, moral rights, it's actually a very simple theory. It's the idea that authors not only have a commercial interest in their work, but they also have non-commercial interests arising out of their creative activity. Now, when we classify a work as a copyright work, a number of different rights arise. Rights to restrict publication of that work by other people, to restrict the making of copies, the making of derivative works, and so on and so forth. So although we use a monolithic term, copyright, there's actually a great diversity of rights that can be included under that umbrella. Now, fortunately for us, most of those rights, the vast majority, fall into two major groups, the economic rights and the moral rights, just as illustrated in this small flowchart. And under the section on moral rights, I've indicated what are some of the main rights involved when we discuss moral rights and use that terminology. There are two major rights, a right of attribution, which of course is the right to have your own work attributed to you by name, and secondly, a right of integrity, which is a right to protect your work from harm. And I mentioned parody in the third little box, which you may not be able to read, because that's an area where a balancing of rights is involved, moral rights of the author versus the economic and moral rights of the person who makes the parody. So that's a very stimulating, interesting area of balancing of rights in relation to moral rights. Of course, there are many other rights which could be possible. For example, if we take France, France is always a good country to look at when we talk about moral rights because it is the country where the idea of moral rights originated, and it continues to have the most extensive scheme for the protection of moral rights in the copyright law of any country in the world. Rights in France include a right of disclosure or first publication. They also include a right to withdraw your work from public circulation for various reasons. For example, if your views have changed since you first published the work. So they have a number of rights beyond the basic platform of attribution and integrity, which I've identified as a major component of moral rights. So historically, as you can see, the doctrine of moral rights is associated with France and indeed with other civil law countries. Pretty much all of the countries of continental Europe have their own approach to the treatment of moral rights of authors. And in the laws of all of those countries, moral rights are a centerpiece of copyright protection. In the common law countries, of course, the situation is quite different. We are relative newcomers to moral rights, and we do tend to experience this doctrine as an area of controversy in our law. And that applies universally to all common law countries, the United States, the United Kingdom, Canada, Australia, and if we want to go a little bit further afoot, to India and some of the other former colonies as well, as you will see when I get a little bit further into this presentation. Let me not forget to mention New Zealand as well. The interesting thing is that in spite of the fact that we as common law lawyers tend to see this area as quite controversial, it is probably the aspect of copyright that is most widely recognized around the world. So almost every country outside of the common law sphere has not only some protection for moral rights, but a certain focus on it in their copyright legislation. And I think that in the era of digital technology, we're going to see a shift in the copyright laws of the world towards more recognition for moral rights. So the objectives of this talk today are quite simple. I want to begin by examining the status of moral rights and moral interests in the United States. I want to show why I think these interests are particularly important in the digital era. And then I want to go on, as I said, to consider how moral rights are protected in some representative jurisdictions of the world. And one of the interesting things that I hope you'll see as I get into that discussion is how this legal concept of moral rights is actually amazingly malleable and it takes on different characteristics depending on the cultural and technological environment where it comes into play. In the United States, actually, the concept of moral rights has been known for a very long time, at least since 1948, when there was a major case on the issue in New York State, the Shostakovich case. This is a classic case in moral rights jurisprudence, and it involved the music by a number of prominent composers from the then Soviet Union in an anti-Soviet film called The Iron Curtain. And fortunately, there's a Canadian connection here as well, because the film actually had to do with the activities of Soviet spies in Canada. The case was brought in the United States by the Soviet government, and the Soviet government wanted to suppress the film on the grounds that the moral rights of the composers had been violated by the association of their music with the political views in the film. Now, in the case, an American judge found himself in this interesting position of exploring the idea that moral rights might be a part of American law. And he did this in good faith. He considered the possibility that the composer's moral right of integrity had been violated. When we read the judgment, there's a very striking recognition that in certain cases, here in the United States, there will be a violation of moral rights. And it's very interesting. He identifies two particular situations where that might happen. The first being in circumstances where there is a direct mistreatment of the work, so there's an intervention in the work that causes harm or damage. And secondly, very interesting indeed, that for the purpose of protecting works which are in the public domain, there may actually be a relevance and a need to recognize moral rights. So he seems to view the right as a way potentially of protecting valuable cultural heritage. But the judge then goes on to note that there are several practical difficulties with recognizing moral rights in the United States, indeed. And the first point that he raises has to do with the standard to be applied. And in his words, he asks, is the standard to be good taste, artistic worth, political beliefs, moral concepts, or what is it to be? So it's a very fluid concept. Second point the judge raises, he says it's going to be difficult to decide how to balance the moral right of the author against the rights of other members of society. And thirdly, he's concerned about the difficulty of finding appropriate remedies within the terms of US law. So if I can summarize, back in the time of Shostakovich, 1948, there were three obstacles to US moral rights. The first, clearly, was that no codification of any moral rights existed. So, accordingly, secondly, if such a right were to be recognized, it would be so vague that it would cause troublesome uncertainties. Okay, for example, how could we prove a violation of the right of integrity? What kinds of evidence would be required? Would the burden of proof fall on the plaintiff or the defendant in such a case? And what standard of proof would we be expected to apply? Thirdly, the integrity right as it was recognized in worldwide jurisprudence meant something specific, as the judge noted in the Shostakovich case. It meant that the work itself had to be modified, touched in some way, before the integrity principle could be invoked. The association of a work with discordant political views was not enough in itself to qualify as a violation of the right of integrity. And an interesting footnote to this case, the very same issue was brought before the courts in France, the very same case, and in the French courts, the plaintiffs won. Loss in the United States, a win in France. So you can see that the facts of the case are rather unattractive, but in spite of that, the idea of the right of integrity as a presence in American law did receive a fair and very interesting consideration by the judge. Now, I think, we need to revisit the ruling in Shostakovich because of a number of changes